We are now on the record. My name is James Arndt. I'm a videographer for Galco Litigation Services. Today's date is February 7th, 2019, and the time is 9:07 a.m. This video deposition is being held in St. Louis, Missouri in the matter of the National Prescription Opiate litigation for the United States District Court for the Northern District of Ohio, Eastern Division. The deponent is John Gillies. Will counsel please identify themselves?
Good morning, everyone. David Cove, Keller Roback on behalf of the plaintiffs.
From Keller Roback on behalf of the plaintiffs.
Dean Kawamoto, also from Keller Roback for the plaintiffs.
Sarah Harmon with Armstrong Teasdale for Cardinal Health Inc.
Trisha Hersfeld from Brandsetter Strange and Jennings on behalf of the Tennessee plaintiffs.
Brandy Rungeon from Jones Day on behalf of Walmart.
Joshua Goldstein, Ropes and Gray on behalf of the witness, Mallinckrodt LLC and Spec GX LLC.
Andrew O'Connor on behalf of the witness, Mallinckrodt LLC and Spec GX.
Will attorneys present by phone please identify themselves?
Caitlin Michael from Arnold and Porter on behalf of Endo and Power Entities.
Dana Russo, Reed Smith on behalf of AmerisourceBergen Drug Corporation.
The court reporter is John Arndt, and he will now swear in the witness.
And sir, if you could raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Morning.
Would you please state and spell your name for the record?
Sure. John Gillies, Gillies.
And Mr. Gillies, where do you currently reside?
In St. Louis, Missouri.
Okay. And have you had your deposition taken before?
Yes.
Okay. Approximately how many times?
Twice.
Okay. And was that in connection with your time at FBI or in connection with your time at Mallinckrodt?
With my previous employer.
Okay. Not Mallinckrodt.
Not Mallinckrodt.
Okay. So you understand generally how these depositions go, but just as a brief reminder of the important rules to me, it's very important that we create a clean record. As we alluded to before, the court reporter has the most important job here, so it's important not to speak over one another. So please wait until I finish my question before moving on to your response, and likewise I'll wait until you finish your response before moving on to my next question, okay?
Yes.
It's also very important that to the extent I ask a yes or no question and your answer is in fact yes or no, please say those words rather than shaking your head or nodding your head. Sound good?
Yes.
Okay. And from time to time, counsel, your counsel or other counsel might object to my questioning, but unless you get a clear instruction not to answer, I'd ask that you respond to my question. Does that sound good?
Yes.
Okay. And Mr. Gillies will be here for a substantial period of time today, so to the extent you need breaks, please ask, and we'll do our best to accommodate, okay?
Thank you.
Mr. Gillies, is there anything that you can think of today that will prevent you from testifying truthfully or honestly?
No.
Great. I understand that you have been designated on behalf of Mallinckrodt to testify on certain topics pursuant to a 30B6 notice. Is that your understanding?
Yes.
Okay. I'm going to go ahead and hand you a copy of what's going to be marked as Gillies Exhibit 1. Yeah, sure. And I'll represent for the record that this is the amended notice of deposition pursuant to Rule 30B6 that we issued to Mallinckrodt. Does that look familiar to you, Mr. Gillies?
Yes.
Okay. And just so I understand and just so the record is clear, you are here testifying on behalf of Mallinckrodt, is that correct?
Correct.
And Mallinckrodt is defined as Mallinckrodt LLC and Spec GX LLC, is that correct?
Yes.
And are you also testifying on behalf of Mallinckrodt PLC today?
No, not that I'm aware of.
Okay. And I'll note for the record, as counsel is aware, Mallinckrodt PLC has moved to dismiss themselves from this litigation, but it is certainly plaintiff's position that the PLC should be in the litigation, and we expect this testimony to be on behalf of the PLC as well.
And we want to make clear that his testimony today is only on behalf of LLC and Spec GX. PLC is not subject to the jurisdiction of the Northern District of Ohio.
Now, throughout this day, we'll be taking a look at that notice shortly, but throughout this day we'll also be looking potentially at some documents that include Covidian email addresses and Covidian labels. Can we agree for purposes of the deposition today that Mallinckrodt includes Covidian?
Yes.
Okay, and same with Tyco. There'll be perhaps some Tyco email addresses and some Tyco documents. Can we agree that Tyco is synonymous with Mallinckrodt for purposes of today's deposition?
I just want to be very clear that those are other companies, and he's authorized to speak, as he said, on behalf of LLC and SpecGX.
When I refer, I understand, Andrew, when I refer to Tyco and or Covidian in some documents, unless there is a clear objection or clear instruction otherwise, can we agree that just for ease of reference, that when I refer to Tyco and or Covidian, it's also synonymous with Mallinckrodt?
Yes.
Okay, great. Turning to this deposition notice, as we discussed before, there are some topics that you have been designated to testify on behalf of Mallinckrodt, and that includes, if you turn to page 5, topic 1. Is that correct?
Yes.
Okay. And I also understand that you have been designated by Mallinckrodt to testify as to portions of topic 2. Is that correct?
Yes.
And in particular, I think there are some carve-outs there. So I believe that your testimony today is specifically regarding suspicious order monitoring and potential diversion.
Yes.
Is that correct? Okay. And just so the record is clear, let me read into the record the topic as I understand that you are testifying on behalf of Mallinckrodt today. And that would be, quote, the role of wholesalers, distributors, and pharmacies, including but not limited to defendants, in the supply chain for your opioid products and the responsibilities of each with respect to suspicious order monitoring and potential diversion, end quote. Do you understand to be testifying on that topic today?
Yes.
Great. Now, in addition, you are also testifying on behalf of Mallinckrodt for portions of topic 3. Is that correct?
Yes.
And again, just so the record is clear, let me read the portion of topic 3 that I believe that you are testifying on behalf of Mallinckrodt, and that would be, quote, warning letters sent to you by the DEA and any other communications between you and the DEA regarding your marketing of your opioid products, your response to these letters, all subsequent actions you took in response to those communications, and all budgets for any such actions by year, end quote. Is that a correct understanding of what you're testifying on behalf of?
Yes.
Great. Now, I also understand that you are testifying on behalf of Mallinckrodt for portions of topic 4. Is that correct?
Yes.
And again, so the record is clear, the portion of topic 4 that you are testifying on behalf of Mallinckrodt today is, quote, your interactions with the DEA regarding the scheduling of controlled substances, the setting of quotas, or the distribution of controlled substances, including compliance, regulatory and administrative actions, communications, and penalties, end quote. Is that consistent with your understanding that you are testifying on behalf of Mallinckrodt on that topic?
Yes.
Great. I also understand that you are testifying on behalf of Mallinckrodt on topic 5. Is that correct?
Yes.
And in addition, topic 6.
Yes.
Also topic 7.
Yes.
Okay, and turning to the next page, on page 7, there is also topics 14 and 15. It's my understanding that you are testifying on behalf of Mallinckrodt on those topics. Is that accurate?
Yes to 14. Yes to 15.
Great. Then finally, if you move forward to page, I believe, page 11, I understand you are also being designated to speak on behalf of Mallinckrodt on portions of topic 27. Is that accurate?
Yes.
And again, so the record is clear. The portion of 27 that you will be testifying on Mallinckrodt today is, quote, to the extent not encompassed within other topics, your suspicious order monitoring and compliance concerning your generic opioid products. Is that accurate?
Yes.
Great. Thank you for that.
Counsel, just for clarity, I think
Sure.
on number 4, per our letter of October 15th, Mr. Webb was designated to testify regarding all of 4 except for the setting of quotas. And it's only the setting of quotas that's within Mr. Gillis's topics.
And Andrew, I believe that you had sent an email in early January before Mr. Webb's deposition clarifying that actually Mr. Webb was only testifying on behalf of communications and interactions with the FDA.
Okay.
And I had sent a follow-up email confirming.
I'm happy to confirm that at the next break.
Okay.
And we can handle it.
I think regardless, some of the questions that I'll be asking today, just for your edification, that relate to the DEA could fall under other categories.
Fair enough.
So
Thank you.
if it becomes an issue, we can discuss and put it on the record.
Okay.
Now, for the topics that we went over today, just a moment ago, again, just so the record is clear, you understand that you are speaking on behalf of Mallinckrodt, correct?
Yes.
And you are not testifying in your individual capacity.
Correct.
And you understand that your testimony will bind Mallinckrodt, is that correct?
Yes.
Great. Mr. Gillies, what did you do to prepare for this deposition?
I met with counsel a number of times, reviewed policies, procedures, emails, other documents.
And when you said counsel, is that Mr. O'Connor and Mr. Goldstein here?
Yes.
Any other additional counsel?
Mr. Davison.
Okay. And approximately how many times did you meet with them?
4 or 5.
Okay.
4 in person, 1 video conference.
And when was the date of the first preparation session?
I believe it was in September of 2018.
Okay. And approximately how many hours would you say you've spent preparing for this deposition?
Approximately 80 hours total.
And when you said a moment ago that you were reviewing documents, well, strike that. The 80 hours in preparation, are those all hours you spent with counsel, or are you talking about additional hours that you spent on your own preparing?
No, that would be a combination of counsel and individual.
Understood. Approximately how many hours did you meet with counsel?
Approximately 40.
Okay, great. And when you said a moment ago that you reviewed some documents, were these all documents that were selected by your counsel?
You can answer that.
Yes.
In other words, did you provide any documents to your counsel, or did you independently review any documents on your own outside of counsel's presence?
No.
Great. And have you reviewed any of the court pleadings in national opioid litigation?
So can you further define that for me?
Sure. Have you looked at the applicable complaints in this action?
Yes.
Okay. Which ones?
The original one?
Got it. And I'm not trying to put you through a
No,
legal test at all. I'm just trying to get an understanding of what documents you may have looked at. So were these documents also selected by counsel?
Yes.
Great. In addition to complaints, Were there any other pleadings or documents that look similar to, for example, the 30B6 notice that's in front of you that you reviewed?
I would have looked at this document, but I don't recall seeing anything else like this.
Okay, thanks. And in preparation for this deposition, did you speak with any current or former employees at Mallinckrodt?
Yes.
Okay. Which ones?
Karen Harper.
Okay. And when did you speak with her?
It would have been in January.
Okay, January of this year.
I'm sorry, January 2019.
Great. And did you speak with her specifically about your deposition or this case, or what did you guys discuss?
Would have discussed a question I had on one of these topics.
I see. And which topic was that?
Counsel, I'm going to object to the extent some of that discussion took place in the presence of counsel. I instruct the witness not to answer under attorney-client privilege.
Okay. Do you recall, are you going to follow that instruction?
Yes.
Okay. Do you recall which topic you discussed with Ms. Harper?
Same objection, same instruction.
Other than Ms. Harper, did you speak with any other current or former Mallinckrodt employee outside the presence of counsel?
No.
Okay. And I'm sure you're aware that there are other depositions taking place in this case of Mallinckrodt current and former employees, correct?
Yes.
And did you review any transcripts of these depositions?
No.
Okay. And Mr. Gillis, I assume that Mallinckrodt is paying for your representation by Andrew and Joshua today. Is that correct?
Are they paying me or paying them? I'm sorry, I don't understand the question.
Are you being compensated in any way for your testimony today individually?
I mean, I'm employed by Mallinckrodt, so my compensation comes from my employer.
Outside of your regular compensation, are you getting any additional compensation?
No.
And are you paying for your counsel, both in terms of preparation for this deposition and or conducting this deposition?
Me personally?
Yes.
No.
Great. You can set that aside. You may want to refer to it from time to time, but we can move that aside for the moment.
Okay.
Mr. Gillies, you're currently Director of Global Security at Mallinckrodt, is that correct?
I'm currently the Vice President of Global Security.
Vice President, thanks for the clarification. Have you ever been a Director of Global Security or a Director at Mallinckrodt?
Yes.
Okay, and how long ago was that when you first became Director?
Yes, I was Director when I joined Mallinckrodt in June of 2012.
Okay, and are you still currently a Director or are you no longer a Director?
So I'm no longer Director.
Okay, and when did that occur, that you no longer became a Director?
I can't recall the exact date, but I believe it was 2015.
Okay, and so you have been Vice President of Global Security since 2015?
Correct.
Okay, and you said a moment ago that you became Director in 2012. Is that also when you joined Mallinckrodt?
Yes.
Okay, and approximately when in 2012?
June of 2012.
Okay. Is it accurate to say that currently one of your primary responsibilities is to oversee Mallinckrodt's compliance with the Controlled Substances Act?
I'm one of the members of the Suspicious Order Monitoring Team.
Okay. And in addition to being one of the members of the Suspicious Order Monitoring Team, do you have additional duties to ensure that Mallinckrodt complies with its duties under the Controlled Substances Act?
Objection to form.
Yes.
Okay. And for purposes of the deposition today, is it okay if I refer to the Controlled Substances Act as the CSA?
Yes.
And okay to refer to Suspicious Order Monitoring as SOM?
Yes.
Okay, great. And I assume that you're familiar with the CSA, correct?
Yes.
And you're familiar that a fundamental duty of any registrant of the CSA is to maintain effective controls against diversion?
Objection to form.
Yes.
Okay. And is it also fair to say that one of the fundamental duties of the CSA is for a registrant to design and implement a system to identify and detect suspicious orders?
Objection to form.
Yes.
Okay. And you would certainly agree that Mallinckrodt, as a registrant of the CSA has these duties, correct?
Objection to form.
Yes.
Now, is it accurate to state that Mallinckrodt did not always comply with these duties?
Objection
No.
to form.
Okay, well, you're familiar with the Memorandum of Understanding between the DEA and Mallinckrodt, correct?
Yes.
And we'll get into more of the details later, but you're familiar with all the provisions of the Memorandum of Understanding. Is that fair?
Yes.
And in the Memorandum of Understanding, there's a provision referenced in that agreement titled Admission of Responsibility. Are you familiar with that provision?
Objection to form.
Yes.
Okay. And we can refer to the document later if we need to, but in that provision, there is a statement that indicates that Mallinckrodt, from certain times from 2008 to 2012, did not always comply with the standards set forth in DEA letters in 2006 and 2007 regarding its suspicious order monitoring program. Isn't that accurate?
Objection to form.
That's my understanding without reading that document.
Okay. So we had just talked about one of the duties under the CSA being a registrant's obligation to design and implement a system to identify suspicious orders. Do you recall that?
I'm sorry, could you say that again?
Sure. We had just talked about one of the duties under the CSA being a registrant's obligation to design and implement a system to identify suspicious orders.
Yes.
Okay. And in the admission of responsibility in the MOU, Memorandum of Understanding between Mallinckrodt and DEA, Mallinckrodt acknowledged that from certain times from 2008 through 2012, it did not always follow the recommendations set forth in DEA letters in 2006 and 2007 regarding SOM programs. Isn't that accurate?
Objection to form.
No.
Okay.
No.
Well, we'll get to the MOU later
Okay.
then. Again, I don't want this to be a memory test or anything,
Yeah.
so we'll talk about those provisions later. Going back to your background, I've seen in certain documents that you have a BA in accounting and business from Illinois State. Is that correct?
A Bachelor's of Science.
Sorry, I apologize for that. Bachelor's of Science. So you have a Bachelor of Science in accounting and business administration from Illinois State.
That's
Is that
correct.
correct? Okay. And you graduated in 1982?
Yes.
Okay. And after graduation, you went to work for the FBI, is my understanding. Is that correct?
Yes.
Okay. And was that immediately after graduation?
No.
What did you do between graduation and working for the FBI?
I was doing accounting work, and I joined the FBI in October of 1983.
Okay. And where did you do your accounting work?
It was in Chicago.
Okay. Who was your employer?
It was Curtis Kruger, CPA, excuse me.
And when you went to work for the FBI, what was your first job at the FBI?
It was a general support position,
General support in what division?
Chicago division.
Okay. And in what department?
It was for the entire office.
I see. And I don't want to go over too much of your background. There's, as you understand, you have a deposition under your personal capacity tomorrow. But I do want to understand when you became a special agent in charge of the Miami division.
October of 2009.
Okay. And how long were you in that role?
Until June 2012.
When you went to go work for Mallinckrodt?
That's correct.
Okay. And both as a special agent in charge of the Miami division of the FBI, and even prior to that, I want to get an understanding of when you first became aware of the opioid crisis.
You can answer at a general level. As we discussed, there's 2E regulations that govern his ability to speak to confidential information. So at a very high level, you can answer whether you were aware.
It would have been during that time between 2009 and 2012.
Okay. So you, and during that time, given that you were in Florida, I presume that you became aware of certain issues with respect to the opioid crisis in Florida in particular as well, correct?
Again, you can speak to your general awareness to the extent you don't reveal any confidential government information subject to the TUI regulations. If you can't answer, then I would object and instruct you not to.
Could you restate that question? I'm sorry about that.
Sure, I can repeat it.
Yeah, could repeat it. That's fine.
Given that you were in Florida, I presume that you became aware of certain issues with respect to the opioid crisis in Florida in particular, correct?
Object to the form and give the same instruction with respect to the TUI issue.
I'm going to take my counsel's advice on that.
Sure. And Mr. Gillies, I'm certainly not trying to pry into anything that might be confidential or violate any of your obligations under the law. I'm just trying to get a general understanding of whether or not you became aware of certain issues in Florida related to the opioid crisis in the 2009 through 2012 time period.
I would make the same objections.
I'm going to have to take my counsel's advice on that.
Okay, let me try it this way. Mr. Gillies, there's certainly publicly available information about the role you played with respect to certain investigations that occurred in Florida. Are you aware of those?
Yes.
Okay, so I'm just asking, with respect to the publicly available information out there that suggests that you played a role in, for example, prosecution of certain pill mills in Florida, I just want to make sure the record is clear today. At some point in time during the 2009 and 2012 time period, or perhaps before, you became aware that there were certain issues with respect to the opioid crisis in Florida. Is that fair?
Object to form, and you can answer with respect to publicly available information.
Yes.
Now, is it also accurate to say, putting aside your role in the FBI, is it also accurate to say that Mallinckrodt became aware of certain issues in Florida as alerted by the DEA?
Object to form.
Mallinckrodt became aware of the full scope of the problem after a DEA meeting in August of 2011.
Okay. And setting aside your answer with respect to the full scope of the problem, Mallinckrodt understood that there were certain issues with respect to the Mallinckrodt pills being diverted in Florida prior to that meeting as well, correct?
Objection to form.
Mallinckrodt was aware of an opioid problem, and they were aware of unscrupulous doctors writing scripts for opioids.
And what time period were they aware of this?
Again, they became aware of the full scope after the August 2011 DEA meeting. So they were aware of unscrupulous doctors and some opioid issues prior to that.
Okay. And would it be accurate to say that they became aware of an opioid problem and aware of unscrupulous doctors writing scripts for opioids as early as 2008?
Objection to form.
I don't have any recollection of it being 2008.
Okay. I've probably seen a lot more documents than you have.
I'm sure
but
you have.
have you, in any of your review of documents as selected by counsel today, did you see any reference to a growing opioid crisis and problems in Florida in particular earlier than 2008?
No.
Okay. And again, all these documents were selected by your counsel, is that correct? That you reviewed in preparation for this deposition?
Yes.
Okay. Mr. Gillies, you are aware of the Controlled Substance Compliance Group at Mallinckrodt, is that correct?
Yes.
And were you ever a member of, or are currently a member of the Controlled Substance Compliance Group?
I am a member of the SOM team. When we have a DEA compliance group, is that what you're referring to?
Well, that's actually helpful to clarify because I've seen plenty of references in the documents to both a DEA compliance team and a Controlled Substance Compliance team. Is it your testimony that there are two distinct teams, or are they the same but just used interchangeably?
Objection informed.
So I'm sorry, I'm not familiar with that second term, the Controlled Substance Compliance team. I am familiar with the DEA compliance team.
Got it. And what are the general roles and responsibilities of the DEA compliance team?
I'm not part of that team, so my general understanding is that that team works closely with DEA on any issues. That's where the quota numbers are prepared from.
In addition to quota, anything else?
I'm sure there are.
Okay.
I'm just not part of that team, so I can't give you a list.
And a moment ago, you said you were part of the SOM team. Is the SOM team under the umbrella of the DEA compliance team, or is it a separate group?
Separate.
Okay. And currently, who are the members of the SOM team?
So we have a representative from DEA compliance, from security, from legal, and government compliance. There may be others.
Okay, and is the representative from security, is that you?
Yes.
Okay, and the representatives from legal, who are they?
You can answer that.
Don Lohman, General Counsel.
Is he the only representative of legal on the SOM team?
Jason Tilley.
Okay. Is he also
Associate General Counsel?
Great. And then you mentioned government compliance a moment ago. Who is the individual that is the representative on the SOM team from that group?
Gal Tetzloff.
And have you been a member of the SOM team ever since you joined Mallinckrodt in June of 2012?
Yes.
Okay. And was there ever a period of time in which you were not a member of the SOM compliance team during the time period between June 2012 and current?
I've been a member of the SOM team since I joined Mallinckrodt.
So in your review of documents and in preparing for this deposition today, did you see any reference to a controlled substance compliance group that was ever formed?
I have no recollection of that.
Okay.
But if you have a document, I'll look at it.
Sure. Is it your understanding that prior to your employment at Mallinckrodt, that the DEA compliance team was always separate from an SOM team, or was there ever a point in Mallinckrodt's history where the SOM team was under the umbrella of the DEA compliance team?
Objection informed.
I'm unaware of the SOM team being under the umbrella of DEA compliance.
Okay. And is it your testimony, well, strike that. Did Mallinckrodt always have an independent and separate SOM team?
Objection informed.
So can you define always?
How about from the period of 2008 to the period of when you joined in June of 2012, do you have an understanding of whether or not the SOM team was independent of any other group at Mallinckrodt?
Objection informed.
Yes, I believe them to be independent.
Okay. Now turning back to your testimony a moment ago about how Mallinckrodt became aware of the full scope of the problem in Florida after an August 23rd, 2011 meeting. Is it accurate to state that that the DEA focused particularly on Mallinckrodt opioids of oxy-15s and oxy-30s in particular?
Objection to form.
And I don't know if I heard you misspeak, but August of 2011.
Okay, I may have misspoken, and let me rephrase my question in any event to make it hopefully a little more simple. The DEA met with Mallinckrodt many times during the 2009 through 2012 time period. Is that fair to say?
Objection to form.
I don't know about many times, but we met with DEA.
Okay. Did Mallinckrodt meet with DEA on more occasions than the August 23rd, 2011 meeting?
I'm sorry. Could you give me that date again?
Sure. I believe you said that the meeting was in August of 2011.
That's correct.
Okay. And I believe in particular it was August 23rd of 2011.
So that's what it was. You're throwing the 23rd at me. I'm sorry, I don't have the exact date on that. That's why I was using August of 2011. That's why you were throwing me off. Okay, I'm sorry.
Okay.
Now I understand. Okay.
So in addition to the August 2011 meeting with DEA, Mallinckrodt had additional meetings with DEA regarding diversion of Mallinckrodt opioids. Is that fair to say?
Objection to form.
Mallinckrodt had additional meetings with the DEA. It wasn't necessarily for that purpose.
Okay. And what other purposes were they for?
I mean, they inspect our facilities, and so some of the meetings were about inspections of our facilities.
Sure. And I understand there are a variety of purposes or a variety of reasons for why DEA met with Mallinckrodt. But with respect to diversion of Mallinckrodt opioids, is your testimony today that Mallinckrodt only met once with DEA regarding diversion of Mallinckrodt opioids?
And during which time frame again? I'm sorry.
At any time?
No.
Okay. So in addition to the August 2011 meeting between Mallinckrodt and DEA, there were additional meetings, were there not, where diversion of Mallinckrodt opioids was discussed between Mallinckrodt and DEA. Is that fair to say?
Yes.
Okay. And a moment ago I had referred to oxy-15s and oxy-30s. It's your understanding that Mallinckrodt manufactured generic oxycodone in the 15 milligram strength. Is that accurate?
Yes.
And in addition, Mallinckrodt also manufactured oxycodone 30?
Yes.
And for purposes of the deposition today, is it okay if I refer to those as oxy-15s and oxy-30s?
Yes.
Okay. During the August 2011 meeting, one of DEA's focuses were the diversion of Mallinckrodt opioids, and in particular the diversion of Mallinckrodt oxy-15s and 30s. Is that accurate?
The discussion was about Mallinckrodt oxycodone products going into Florida.
Okay. And in particular, oxy-15s and oxy-30s, or just oxycodone products in general?
'15s and '30s.
Okay. So is it fair to say that Mallinckrodt knew that Mallinckrodt manufactured opioids were being abused and diverted in Florida?
Objection to form.
I don't know about the abuse part, but they would have become aware of some of the diversion of the products.
Okay. And what's your understanding of diversion, Mr. Gillies?
Outside the legal supply chain. So if you write me a legitimate script and I get it filled and I give it to people around this table, there's diversion there.
Okay.
And one of the things we could also do is we could have an employee that diverts product.
And could diversion lead to abuse of a product?
Objection to form.
It could.
Okay. And would you agree that diversion of an opioid product could also lead to its misuse?
Could.
Okay. Is it fair to say that Mallinckrodt was also aware of the Oxy Express?
Objection to form.
I'm not aware of Mallinckrodt being aware of the Oxy Express.
Okay. During both the August 2011 meetings and other meetings, did DEA ever inform or discuss the Oxy Express with Mallinckrodt?
Objection to form.
Not that I'm aware of.
Okay. And in your review of documents today in preparation for this deposition, as selected by counsel, did you see any references to the Oxy Express?
I did not.
Okay. Do you have an understanding of what the Oxy Express is?
Objection. I'm assuming, counsel, you're asking him in his capacity as an employee of Mallinckrodt, did he learn about that term? Otherwise, there's two implications. So you can answer to the extent that it's based on Mallinckrodt knowledge.
No.
Okay. You don't have any understanding of what the Oxy Express is?
So,
And I know that you keep looking at counsel, but I'd ask that unless he actually lodges his objection clearly on the record and instructs you not to answer, that you refrain from looking at him every time that I ask you a question.
I'm not looking at him every time you ask me a question, but I've got legal implications when you ask me this question, so I just want to make sure that I'm not overstepping my legal bounds for my responsibility to my former employer. So I believe I just answered your question when it came to Mallinckrodt.
Okay.
And I'm going to make the same objection, clearly and on the record.
So have you seen any documents at all, that Mallinckrodt documents that reference the Oxy Express?
I have not.
Okay. And have you had any discussions with anyone regarding, outside the presence of your counsel, regarding the Oxy Express?
No.
Okay. So turning back to the DEA compliance group, as it stands today, approximately how many full-time employees are part of the DEA compliance group?
Six or seven
Okay.
is my estimate.
And do you have an understanding of how that has changed over time, if at all?
I don't think it's changed much over time.
Okay. So as far as you know, as far as the DEA compliance group has been in existence, approximately 6 to 7 full-time employees have been part of that group. Is that accurate?
That's my understanding.
Okay. And with respect to, I know we had just discussed the individuals that were part of the SOM team. How many full-time employees are part of the SOM team right now?
Approximately 9.
Okay. And has that changed over time?
It's grown.
Right. And when was the SOM team first created?
I don't know the answer to that.
We can take a look at some documents later, but does it refresh your recollection at all if I say that it's my understanding the SOM team was created in 2008. Is that consistent with your understanding, or are we going to need to look at some more documents to establish that?
Objection to form.
I don't have an understanding of exactly when it started.
Do you have a general understanding of whether or not it started before 2008 or after 2008?
I do not.
Okay. And as we discussed before, with respect to the topics that are outlined in that notice, one of the topics includes Mallinckrodt's suspicious order monitoring system. Is that accurate?
Yes.
And you're prepared to testify on behalf of the company on all things related to suspicious order monitoring. Is that fair?
Yes.
And your testimony is that you don't know today, sitting here, you don't know when the SOM team began?
That's correct. I cannot recall.
Is it going back to the DEA compliance group? I know you had talked about certain things that they were responsible for, but you couldn't recall everything. Is it fair to say that the DEA compliance group is responsible for any DEA reporting requirement?
Objection to form.
Yes.
Okay. And those would include any year-end ARCOS reports that Mallinckrodt has to submit to DEA. Is that accurate?
Objection to form.
Yes.
Okay. And it would also be accurate to say that the DEA, well, strike that. The SOM team, you have testified, is independent from the DEA compliance group. So I want to get an understanding of whether or not the DEA compliance group has any involvement in SOM whatsoever, or if the SOM team runs completely independent of DEA compliance.
Objection to form.
So there wasn't a question there, so I'll just ask the question. Does the DEA compliance group have any responsibility over the SOM team?
There are DEA compliance members on the SOM team.
Okay. And which individuals are those?
Karen Harper, Eileen Spalding, and Rochelle, and I can't recall her last name.
Okay. Are those the only three individuals that are both part of DEA compliance and the SOM team?
That's my understanding.
Okay. And going back to the DEA compliance group, in addition to quota requests and communications with DEA regarding Mallinckrodt's quota, is it also accurate to say that the DEA compliance group has responsibility coordinating any audits done by DEA of Mallinckrodt facilities?
Yes.
Objection to form.
Okay. Is it also accurate to say that the DEA compliance group is responsible for tracking Mallinckrodt's internal consumption of their quota request?
Objection.
Or of the annual quota allocation?
Objection.
Yes.
Earlier we were talking about Mallinckrodt's duties under the Controlled Substances Act. You recall that?
Yes.
Now, in addition to the statute, which obviously is complex and has many layers to it, with respect to suspicious order monitoring in particular, is it accurate to say that Mallinckrodt received certain letters in the 2006 and 2007 time period regarding its obligations under the CSA, and in particular its obligations to design and implement a suspicious order monitoring system?
Objection to form.
We received a DEA letter 2007 in 2007. The 2006 letter, I don't believe we received a copy of that until later in 2007 or 2008.
Okay. I'm going to go ahead and hand you a copy of what's been marked as Gillies Exhibit 2. Go ahead. I should better mark for you too. Just it doesn't have to be there. And for the record, Gillies Exhibit 2 is MNK-T1_000273575. And then I'm also going to hand you a copy of what's going to be marked as Gillies Exhibit 3. And for the record, that ends in Bates 270069. And let's start with the second exhibit, or excuse me, the Gillies Exhibit 2.
Okay.
And I see that there's a cover letter, and we could talk about that in a moment, but this is, the letter that you see attached to this email is a September 27th, 2006 letter from the DEA. Is that accurate?
Yes.
And this, it's signed by Joe Ranazizi.
Yes.
By the way, did you know Joe Ranazizi prior to the time that you joined Mallinckrodt?
No.
Okay. Do you know him now?
I know who he is.
Okay. But you don't have a personal relationship with him?
I do not.
Okay. And in addition to the letter that you see that's reflected in Exhibit 2, there's another letter that's in front of you that's marked as Gillies Exhibit 3 that's dated December 27th, 2007. Is that correct?
Yes.
And are these the two letters that we just discussed a moment ago that Mallinckrodt received regarding its duties under the CSA?
Objection to form.
Yes.
Okay. And throughout today, we might be referring to these letters. Is it okay if we refer to these as the Ranazizi letters?
Yes.
Okay, great. So turning back to, sorry to jump around, but turning back to Gillies Exhibit 2, I just want to make sure I understand your testimony a moment ago. You said that you don't believe that Mallinckrodt received this letter immediately after it was dated September 27, 2006. Is that correct?
That's correct.
Okay. And your testimony is that Mallinckrodt received it at some point in time in 2007 or 2008?
Correct.
Okay. And I just want to clarify for the record, if you look at the cover email, you see Ms. Harper sending this letter around. Is that accurate?
Objection to form.
So this is from Karen, and the attachment says DEA letter, September 27th, 2006.
Okay. So I just want to clarify for the record. I want to make sure that it's clear. Is it accurate to say that Mallinckrodt received, or individuals at Mallinckrodt received this letter in 2007?
The date of this is December 13th, 2007.
Okay, so yes or no. Is it accurate to say that Mallinckrodt received the September 27th, 2006 Ranazizi letter at some point in 2007?
Yes.
And by the way, there are some individuals that are referenced in this letter at Mallinckrodt, including individuals by the name of Eldon Hansen and Todd Forthouse. Do you see that?
Yes.
Do you know who they are?
I'm familiar with Eldon's name, but not Todd.
And who is Eldon Hansen? And what was
I'm
his
sorry,
role at
I
Mallinckrodt?
don't know what his role was.
Okay. Fair enough. And there are also references, if you look on pages 2 and 3 of this email, to Vince Kamen and Tim Wright. Do you know who those individuals are?
I do not.
Okay. Now, if you look at the second page of this email, sorry to stick
This
on
one?
that exhibit.
Okay.
Yeah, thank you. So the second page of the email, about 2/3 of the way down, there is an email from Dirk Stevens to Eldon Henson. Do you see that? From December
Yes.
13th.
Yes.
10:45. And again, Eldon Hansen was a Mallinckrodt employee. Is that correct?
Yes.
Okay. And in that email, he is being asked by Dirk Stevens, quote, "Do you have a diversion policy?" Do you see that?
Yes.
What is your understanding? Well, strike that. With respect to Mallinckrodt's obligations under the CSA, and in particular its obligations to design and implement an SOM program, when did Mallinckrodt first memorialize in writing a policy with respect to these obligations?
Objective form.
So Mallinckrodt always had an SOM program. But I do not know the date of any formal document.
Okay. When you say that Mallinckrodt always had an SOM program, do you have an understanding of when it first began?
I do not.
Okay. And do you have, I assume I know the answer to this, but when Mallinckrodt first implemented an SOM program, do you know if there was any policy memorialized in writing regarding that program at that time?
I do not.
Okay. Now turning to the top of the first page, the Karen Harper email to Bill Ratliff. There's an indication, do you see about 3 lines down, where she indicates that, quote, she was forwarded policy E9 for St. Louis and A14 for WGTC regarding the same.
Okay.
And for ease of reference, you can see that obviously the
Okay.
exhibit is in front of you, but if you'd like to look at the big screen, it's there behind me as well. Do you have any understanding what the security policy E9 is?
I do not.
Okay, or do you have any understanding of what the A14 for WGTC is?
I do not.
Okay. Is there any indication in that email that Karen Harper is actually providing anyone with the diversion policy requested in the previous email we looked at?
Could you say that again?
Let me ask a different way. Do you have any understanding whether Mallinckrodt, as of December 2007, had a written SOM policy?
Yeah, I'm unaware whether they did or did not.
Okay. You can set that aside and look at Gillies Exhibit 3. And so this is the second Ranazizi letter that Mallinckrodt received from DEA, is that correct?
Yes.
And there's a received stamp that indicates that Mallinckrodt, in fact, received this at least no later than January 4th, 2008. Is that accurate?
Yes.
Okay. And this particular letter is specifically addressed to the Mallinckrodt Hobart facility.
Yes.
And so the record is clear. There's no dispute that Mallinckrodt received this letter, correct?
Correct.
By the way, do you have an understanding of who these Ranazizi letters were circulated to at Mallinckrodt?
No.
Do you know whether or not, well, strike that. Turning to this letter, there are a series of statements being made with respect to registrant's duties under the CSA. Is that accurate?
Yes.
Okay, and in the second paragraph, there is a statement made by DEA that, quote, in addition to and not in lieu of the general requirement under 21 U.S.C. 823, that manufacturers and distributors maintain effective controls against diversion, DEA regulations require all manufacturers and distributors to report suspicious orders of controlled substances. Title 21 CFR 1301.74b. Did I read that portion correctly?
That's what this letter states.
Okay. And so is it accurate to say that Mallinckrodt knew that the obligation to report suspicious orders of controlled substances was an additional requirement under the CSA as required by the CFRs?
Objection to form.
Yes.
Okay. And moving on to the second part of that sentence, the letter continues, quote, well, strike that. The letter indicates that DEA regulations, quote, require that a registrant design and operate a system to disclose to the registrant suspicious orders of controlled substances, end quote. Did I read that correct portion of the paragraph correctly?
Yes.
And so, in addition to the duty to maintain effective controls against diversion, Mallinckrodt knew that it had to design and operate a system to disclose to the registrant suspicious orders of controlled substances. Is that accurate?
Yes.
Okay. And moving on to the next sentence, it indicates that the regulation, let me be clear, the next sentence states, quote, the regulation clearly indicates that it is the sole responsibility of the registrant to design and operate such a system, end quote. Did I read that correctly?
Yes.
And so is it fair to say that Mallinckrodt knew as of the date of receiving this letter that the DEA expected the sole responsibility to design and operate an SOM system to lie with the registrant, in this case Mallinckrodt? Is that correct?
Yes.
Now, moving on to the third paragraph, the second sentence indicates, quote, filing a monthly report of completed transactions, for example, excessive purchase report or high unit purchases, does not meet the regulatory requirement to report suspicious orders, end quote. Did I read that correctly?
That's what it says.
Okay. So is it fair to say that Mallinckrodt understood that simply filing a monthly excessive order report would not meet the regulatory requirements under the CSA?
Objection to form.
But when this letter received, that was the industry standard prior.
Okay, and I understand, but my question was just simply a yes or no question. Is it fair to say that Mallinckrodt understood that simply filing a monthly excessive order report would not meet the regulatory requirements under the CSA as of the date of this letter?
Objection to form.
Yes.
Okay. So if Mallinckrodt was sending monthly reports to DEA after January 4th, 2008, that would not be consistent with the standards set forth in this letter. Is that accurate?
Objection to form.
Yes.
Okay. Going on to the next sentence, the letter indicates that, quote, registrants are reminded that their responsibility does not end merely with the filing of a suspicious order report. Registrants must conduct an independent analysis of suspicious orders prior to completing a sale to determine whether the controlled substances are likely to be diverted from legitimate channels. Did I read that correctly?
Yes.
Okay. So again, is it fair to say that the DEA expectation as of the date of this letter was that, and Mallinckrodt in fact understood that their responsibilities do not end with merely filing a suspicious order report. Is that accurate?
Objection to form.
Yes.
In other words, Mallinckrodt must, as of the date of this letter, conduct an independent analysis of suspicious orders prior to completing a sale, to determine whether the controlled substances are likely to be diverted. Is that accurate?
Objection.
Yes.
So as of the date of this letter, it would be accurate to say that if Mallinckrodt released an order prior to completing a sale and without doing any sort of independent analysis, would not be consistent with the standards set forth in this letter.
Objection to form.
I'm sorry, could you state that one more time?
Sure. Would it be accurate to say that if Mallinckrodt released an order prior to completing a sale and without doing any sort of independent analysis, that would not be consistent with the standards set forth in this letter?
No.
Same objection.
Okay. It would not be accurate to say that?
Correct.
Okay. And why is that?
This is referring to suspicious orders.
I see. I see what you're saying. Let me rephrase my question. So, would it be accurate to say, well, strike that. In the third sentence that we just read, the DEA provides guidance, does it not, that registrants must conduct an independent analysis of suspicious orders prior to completing a sale?
Yes.
Okay. So, are you suggesting that that provision only applies with respect to a suspicious order, but not any other order?
Yes, that's what the regulation says.
Okay. And what is your understanding of what constitutes a suspicious order?
So DEA defines it as size, normal pattern, and there's a third one.
Yeah.
But
Well, it's actually it's later on in this letter. So why don't we actually turn to that portion of this letter? The fourth paragraph down at the bottom of this page states that the regulation specifically states that suspicious orders include orders of an unusual size, orders deviating substantially from a normal pattern, and orders of an unusual frequency. End quote. Did I read that correctly?
yes.
So is it your understanding that a suspicious order, among other things, constitutes those elements?
Yes.
Okay. And so would it be accurate to say that one purpose of why Mallinckrodt designed and implemented a suspicious order monitoring system is to identify orders of an unusual size?
Yes.
Okay. And also to identify orders that deviate substantially from a normal pattern?
Yes.
Okay. And also, Mallinckrodt designed and implemented an SOM program to identify orders of an unusual frequency?
Yes.
Okay. Would you agree with me that one of the purposes of identifying a suspicious order is also to make sure that Mallinckrodt fills orders only for legitimate scientific and medical means?
Objection to form.
Yes.
Now, is it also fair to say that an effective SOM program would also be able to identify whether a pharmacy or clinic is ordering excessive quantities of one particular controlled substance relative to others it orders?
Objection to form.
So could you further define that?
Well, is one purpose, well, would you agree with me that a pharmacy that orders 90%, for example, 90% of one particular drug relative to others would warrant further investigation?
Objection to
So,
form.
so I'm not going to see that as the manufacturer.
What do you mean by that?
I'm not selling to pharmacies. We sell to the distributors and wholesalers who sell to the pharmacies. So I'm not going to see any other product, and we're only selling, the generic controls to the distributors and wholesalers.
At a certain point in time, Mallinckrodt became aware and had access to information regarding downstream transactions between its wholesale distributor customers and pharmacies and clinics. Is that accurate?
With pharmacies, not all pharmacies, some pharmacies.
Okay. So, yes or no, at a certain point in time, Mallinckrodt became aware and had access to information regarding downstream transactions between its wholesale distributor customers and pharmacy and clinics. Is that accurate?
Objection to form.
Could you restate that question, or at least just repeat it one more time?
Sure. At a certain point in time, Mallinckrodt became aware and had access to information regarding downstream transactions between its wholesale distributor customers and pharmacies and clinics. Is that accurate?
For some of them, yes.
Okay. And I know that you just said a moment ago that Mallinckrodt had no visibility beyond, I'm not trying to take words out of your mouth, but you seem to imply that Mallinckrodt did not know what was going on with respect to his drugs after it went to the distributor. That's not entirely accurate. Is that correct?
Objection to form.
That wasn't your question, so that was not my response. That's a completely different thing that you're asking me now.
Okay. So I'll go back to my original question
Okay.
then. Wouldn't it be reflective, well, strike that. Would you agree with me that an effective suspicious order monitoring program would be able to identify whether a pharmacy or clinic is ordering excessive quantities of a limited variety of controlled substances?
Objection to form.
Again, I'm not going to see as the manufacturer all the products that they are or are not ordering.
Yeah. Regardless of whether or not you can see, and we can discuss later about all the pieces of information that a registrant potentially could have, in particular manufacturing registrant. But for purposes of an SOM program, you have responsibilities with respect to the SOM program today, do you not?
Yes.
Okay. And I'm simply asking whether or not you believe, or you would agree with me, that an effective SOM program would be able to identify, regardless of whether or not you think the manufacturer can or cannot identify the details of the downstream transaction, would you agree that an effective SOM program would be able to identify whether a pharmacy or clinic is ordering excessive quantities of a limited variety of controlled substances?
Are you talking about my SOM program?
I'm talking about an effective SOM program.
Okay. Manufacturers or distributors, I mean, that's going to depend on what my answer is.
Okay, let's start with the manufacturers.
No.
Okay, your answer is no.
Yes.
All right. Let's turn to the top of page 2. Actually, before we get there, I also want to ask whether or not you would agree with me that an effective SOM program would also be able to identify whether or not a pharmacy or clinic is ordering from multiple distributors with respect to the same controlled substance.
Objection to form.
That would be a factor to consider.
Okay. And in addition to a factor to consider, would it be reflective of an effective SOM program for a registrant to determine whether or not a pharmacy or clinic is ordering the same controlled substance from multiple distributors?
Objection to form.
It would be a factor to consider.
Okay. And I'm asking a yes or no question.
Sorry.
Yeah. Yes or no, would it be reflective of an effective SOM program for a registrant to determine whether or not a pharmacy or clinic is ordering the same controlled substance from multiple distributors?
Objection to form.
Yes.
Council, we're about an hour and 20 minutes in. Could we take a 5 to 10 minute break?
Sure. Sounds good.
We're going off the record at 10:22 a.m.